ये है पोजीशन अंडर गवर्नमेंट ऑफ इंडिया एक्ट कंपेयर्ड विद द पोजीशन अंडर प्रेजेंट कॉन्स्टिट्यूशन। इसका नीचे जो पैरा है, लास्ट पैरा, वो पढ़ूंगा क्योंकि टाइम मैंने शायद ज़्यादा ले लिया। The juristic aspect of the power as an incident of the American concept of constitution being the supreme law of the land has been stated by Kent. Thus, the constitution is the act of people speaking in their original character and defining permanent conditions of social alliance.
आप कौन से पेज से पढ़ रहे हैं? ये किसी के पास है नहीं पेपर।
23 पेज पे लास्ट पैराग्राफ,
23 और लास्ट पैरा। ऊपर ये पाकिस्तान का पूरा पर्सपेक्टिव है, ये लास्ट एक प्रिंसिपल है, मैंने कहा इसको आपकी नजर कर दूं। द जुडिशरी डिपार्टमेंट प्रॉपर power in the government to determine whether a statute to be or be not constitutional. Interpretation of construction of constitution is as much a judicial act and requires the exercise of same legal discretion as the interpretation or construction of a law. To contend that courts of justice must obey requirements of an act of the legislature when it appears to them to have been passed in violation of constitution, it will be contend that law was superior to the constitution and the judges had no right to look into it in regard to its paramount law. It would be rendering power of agent greater than that of principal and declaring the will of the only one concurrent and coordinate department of subordinate authorities under the Constitution was absolute over the other departments and competent to control according to its own will and pleasure the whole fabric of the government, the fundamental laws on which it rested. The attempt to impose restraint upon the legislature power would be fruitless if the Constitution provision were left without any power in the government. ये आगे केस आ गया 28 पावर टू डिक्लेयर लॉ अनकॉन्स्टिट्यूशनल।
अच्छा ये देखिए, ये मैं तो इससे बिल्कुल ही ये जो अल्फाज का चुनाव है ब्रोई साहब का, द जुडिशरी डिपार्टमेंट, मैं पढ़ रहा हूँ इनके लफ्ज़, जरा एक सेकेंड, द जुडिशरी डिपार्टमेंट इज द प्रॉपर पावर इन द गवर्नमेंट to determine whether a statute be or be not constitutional. मैं तो बिल्कुल इससे इत्तेफाक नहीं कर सकता हूँ। हम ना तो गवर्नमेंट के डिपार्टमेंट हैं, ना ये पावर गवर्नमेंट में वेस्ट करता है टू डिटर्मिन। ये जुमला तो मुझे तो हमारे आइन के तसादुम में है।
ये जुमला वेरी रिस्पेक्टफुली सबमिटेड। चौधरी साहब, मुझे भी ये जुमला इस हद तक अच्छा नहीं लगा। चौधरी साहब
मातहत डिपार्टमेंट बना दिया गवर्नमेंट,
उन्होंने डिपार्टमेंट बना दिया, बीच में हम तो सेपरेशन ऑफ पावर ऐसी पेश कर रहे हैं हमारे सामने। साहब वो बेसिकली जी
चौधरी साहब इधर
जी जी
आप अगर पेज 14 पे आ जाएं, ये किताब छपी है 1958 में
जी दुरुस्त,
जब पहला मार्शल लॉ लगा था और इस कोर्ट ने पहले मार्शल लॉ को वैलिडेट किया था
जी दुरुस्त।
क्या ये उस कॉन्टेक्स्ट में देखा जाए
कि with the passage of time definitely not water already flown under the bridges, I would not say so because जितनी जजमेंट उसके बाद आई, उसके बाद तो माशाल्लाह को हमने मुशर्रफ के माशाल्लाह को
वकील साहब जरा here please. This book ब्रोई साहब की किताब was published in May 1958. मार्शल लॉ लगा था अक्टूबर 1958
जी जी।
This book predates martial law. It was, I think Broi Saab regarded it as an elementary book, if you look at the preface, as an elementary book to teach constitutional law, but it has become his magnum opus, rightly so, but it was published prior to martial law.
That's correct,
It has nothing to do.
जी मैं गुजारिश करूँ
आप जो एक सेकंड जरा अभी आपने जो हमें पैसेज पढ़ के सुनाया ना, जरा वापस उस पे आइए। ये ब्रोई साहब की आवाज नहीं है, ब्रोई साहब is just quoting someone. This is Chancellor Kent, I think.
ये अभी तो मैंने
ये जो है ना, ये जुडिशरी डिपार्टमेंट और गवर्नमेंट, ये अमेरिकन लॉ की इस्तिलाहात हैं। वो मतलब उनका ये नहीं होता है उधर के ये उधर भी trichotomy of power, separation of powers is a very fundamental doctrine of US constitutional
वही
law.
से हमने as a matter of
ये
fact we
falling regarding it, ये government capital G the state. It means it's one of the three branches of the state. It doesn't mean, and these are not Broi Saab's words, he is quoting someone, I think.
ये लेक्चर है, लेक्चर 20 commentaries on American law, volume so and so, Philadelphia.
अब बुनियादी तौर पे
because
उन्होंने
he's
अमेरिकन
quoting
जजमेंट्स भी साइट की
देखिए चॉइस साहब बिकॉज इज कोटिंग समवन ना तो ऑब्वियसली उस कोर्ट में तो उसी की जबान इस्तेमाल होगी ना जो उस ऑथर ने की है
जी दुरुस्त
बट ब्रोई साहब का मकसद यहाँ पे था टू एलैबोरेट द concept of separation of power where as we know the famous words from Chief Justice Marshall in Marbury versus Madison it is the province of the judicial branch to determine and say what the law is. That is being perhaps more broadly explained. This is from a book of 1889, so it's part of settled constitutional law.
लेकिन बुनियादी उन्होंने ये सारे लॉज जो है ये मेडिसिन वाला बेसिकली
हमारे पास
ये इसका भी रेफरेंस दिया है
ये पैराग्राफ 28 आप पढ़ रहे थे वो पढ़िए.
जी जी पैरा 28 जो है
Power to declare laws unconstitutional, not inconsistent with giving effect to the will of the people.
ये बुनियादी तौर पे अगर इजाजत दे तो इट्स वेरी रेलेवेंट. When the courts of law hold certain laws to be unconstitutional, their declarations cannot be construed as defeating the will of the people as expressed in the legislatures of the country. From what has been said so far, it would be apparent that the legal sovereign
That ordains and
that ordains
establishes.
and establishes the Constitution is the people. But this term ought not to be confused with the people as the voters who have returned their representative to act as legislators. The people as a historic community must be distinguished from people as a community of the entire living population with their presidents and predecessors and successors. The people acting solemnly and deliberately, says Professor Willoughby in his book, The Constitution of the United States, in their sovereign capacity, declare that certain matters shall be determined in a certain way. These matters, because of their great and fundamental importance, they reduce to definite written form and declare that they shall not be changed except in a particular manner. In addition to this, they go on to say, in substance, that so decided is their will and so maturely formed their judgment upon the matter, any act of their true will. Therefore, when the courts declare void legislative acts inconsistent with the constitutional provisions, the judges are giving effect to the real will of the people as they have previously solemnly declared. Thus, in effect, the declaring law and constitution, the judges are administering the real will of the legal sovereign, will which having regard to view that they take impugned law has been thwarted by the representative of the people considered as a historic community. My submission is very respectfully